So hello everyone, and thank you so much for joining us this afternoon. My name is Nina Holatova, and I am a lawyer and program coordinator at the Community Legal Education Association, also known as CLEA. For those of you who aren't familiar with what we do at CLEA, we are a nonprofit charitable organization, and our mission statement is unknown rights are not rights at all. We've been working to improve access to justice by providing education, information, and other resources to Manitobans about their rights and the law. And we've been doing this since 1984. So this means that we are very much looking forward to celebrating CLEA's 40th anniversary next year. We offer webinars every spring and fall on a variety of topics, and today's topic is family law variations or making changes to a court order. Just a couple of pieces of housekeeping. Today's presentation is being offered in a webinar format, which means everyone is muted and cameras are off by default. We will have a dedicated time for some questions at the end, but do feel free to send your questions in during the course of the presentation by using the Q&A function, and we can pause for questions as necessary. However, if you do have a more specific question that pertains to your particular legal situation, I encourage you to reach out to our law phone-in program to speak with one of CLEA's lawyers. I also kindly ask that everyone completes our very brief survey after the presentation today. As a nonprofit, feedback from our participants helps us improve the quality of our programs going forward, and it is also invaluable to our funders. So please do fill that out today if you have a chance. With that being said, I would now like to introduce our presenter today, Tanya Keller. Tanya graduated with an LLB from the University of Manitoba in 2008. She articled and practiced as an associate at Darcy & Deacon LLP in family law and estate litigation for almost 9 years before joining the firm of Sternat Menager Law Corporation, where she practiced from 2017 to 2023. Tanya has 15 years of experience in practicing mostly family law with some estates and real estate. She has represented clients in all levels of court in Manitoba. She has a special interest in the intersection of estates and family law. Tanya has been active in the community and enjoys volunteering for various organizations, including the Manitoba Bar Association, where she was the co-chair of the Law Day Committee from 2017 to 2019, co-chair of the Women Lawyers Forum from 2017 to 2018. She also became a council member of the Manitoba Bar Association in 2017, an executive committee member in 2019, and the president of the Manitoba Bar Association from 2022 to 2023. Tanya donates her time to various other community organizations. She enjoys mentoring law students, and one of her favorite volunteer activities is supervising the drop-in clinics at the Legal Help Center. She also enjoys contributing her time and support to the Community Legal Education Association, or CLEA, and of course, we are very, very grateful for that. So with all of that being said, we are so pleased to have her here today, and without any further ado, I will pass it over to Tanya.
Great. Thank you very much, Nina, for that kind introduction. I'm happy to be here today, honored to be asked. I consider it a privilege to be able to share some of our legal knowledge with the general public, and I'm happy to do these presentations. And I'm hopeful that it is useful to people. So if you have questions, I do very much encourage you to ask those questions at any point during the presentation. I'd much prefer to be answering the questions you have that brought you here today than speaking about things that don't matter to you or boring you or putting anybody to sleep, which I'm sure is much easier now on Zoom than it ever was during in-person presentations. But I appreciate everybody being here today too. I also have with me today my articling student, Michaela Bowerly. So she's helped us prepare this lovely PowerPoint presentation, and I'm going to share with you. Okay, so the first thing I was going to mention in varying a court order, just some basic kind of background. There are, in family law, there's two pieces of legislation from which the court can derive jurisdiction to pronounce an order. So there's the federal legislation, which would be the Divorce Act, and the provincial legislation, which would be the Family Law Act. And so if you're a married couple who separated, your relief in your court order could be pursuant to the Divorce Act or the Family Law Act. If you're a common law, it could only be pursuant to the Family Law Act, which just replaced in July this year the Family Maintenance Act. So if you have an order probably, if you're varying it from before July 1st this year, it would probably be pursuant to the Family Maintenance Act as well. And as we know, people's circumstances do not remain stagnant for very long. They're constantly changing. Your children are growing up. And whenever we come to an agreement, or the court makes an order, it's not necessarily meant to last you until those children turn 18 or until they're graduated university and able to support themselves. There's always the possibility that something is going to change that is going to require an update to what your parenting arrangements are or your support arrangements are. So, common reasons that people will request those variations for parenting arrangements, for example, I would say would be just what works for a young child. Let's say, for example, you're sharing care and control of a 3-year-old, and you have what we would call a 2-2-3 schedule, where one parent has them Monday, Tuesday, one parent has them Wednesday, Thursday, and then who had them Monday, Tuesday has them for the weekend, and then it alternates the next week. That level of frequent exchanges works better for younger children. But the family resolution services, for sake of the children experts, have always advised us that more frequent exchanges for younger children, less frequent exchanges are necessary for older children. So as they grow up, it's much more likely that they might move to what we would call a 2-2-5-5 schedule, where instead of let's say parent A has Monday, Tuesday, and parent B has Wednesday, Thursday, and then on week 2, parent B would have Monday, Tuesday, and parent A would have Wednesday, Thursday. It would just continue on where parent A has every Monday, Tuesday. So then when parent A has the weekend, they have a 5-day stretch of Friday, Saturday, Sunday to Monday, Tuesday. So that might change as the children get older. And then they eventually might move to a week on, week off with even older children. Once they're like 8 or 9 or something like that, they might find that works better for them. So those are some reasons. And then when children are teenagers and they get much more vocal about what it is that they want, those might also prompt changes. Moves or relocations can prompt a change for parenting arrangements, or things may have come up that you hadn't contemplated in your original parenting plan that you're going to have to address, and you'd like to get it finalized and formalized in a court order. With support issues, those changes are going to be constant because nobody's income is going to remain exactly the same from year to year. But there are some mechanisms in place to help people so that you don't have to keep coming back to change your court order every year, every 2 years as people's income change. So you can subscribe to the child support recalculation service, which would automatically recalculate the child support for you every 2 years, and the first year after the anniversary of the order. And they can get updated disclosure to help them to be able to do that. And then if that is not enough, or you didn't subscribe to the child support recalculation service, or you're ineligible for it in certain circumstances, somebody's out of province, or you have shared care and control, or income is imputed, then you may have to do a variation to update the child support as well. So that's where these can come into place, the variations of court orders. Of course, the hope is always for most people that you're going to be able to come to an agreement on any changes yourselves. And that's okay if you have not updated your court order from what it was in, say, 2015 when your children were 5 to what it is now, and you've agreed on other arrangements between yourselves without having to get the court order formally varied. That's okay. For support purposes and collection and enforcement purposes, you might need to get the court order varied if you want it updated through the maintenance enforcement program. But if you're opted out of the maintenance enforcement program, or you can agree in writing with the maintenance enforcement agreement maintenance enforcement program on a change, that's okay too. So this is mostly going to be talking about where you haven't been able to agree on that change, or you want to formalize it through the court process and what their requirements are. So that's just a little preamble there. Okay, so the first thing you have to consider are, what are the grounds for a variation? So under the Family Law Act here, we have section 39 sub 2, the factors before making a variation order. The court must be satisfied that the child's circumstances have changed since the original order was made or last varied. So those have to be a material change in circumstance. It's not going to be that they were 5 last year and they're 6 now and things have changed. It's not necessarily going to be because somebody moved 15 minutes away. That's not going to be a material change in circumstance. And what's enough of a change in circumstance for support purposes? I've had a lawyer suggest to me before, if there's roughly a 20% change in income, that's going to be enough of a material change. It's not going to be worth it for most people to go back to court to get a court order varied if it's only like a couple $1,000s, and the impact of a couple $1,000 change in an annual income on the actual table amount of child support might be so negligible that it's not worth it. If you are in the child support recalculation service and they are already updating your child support for you on a regular basis, that will be on a go forward basis. So you may also want to go back to get your court order varied to address any retroactive reconciliation of what child support should have been paid if you find out that the payer's income has changed substantially in the last 2 years, and you want them to make a top up to what they should have been paying in support for child support or spousal support. Okay, and then the grounds under the Divorce Act. So if you're a married couple and your relief is pronounced under the Divorce Act, factors for the child support order. Before the court makes a variation order in respect of a child support order, the court shall satisfy itself that a change of circumstances as provided for in the applicable guidelines has occurred since the making of the last child support order or the last variation of that order. Pretty much the same thing for spousal support order. Before the court makes a variation order in respect of a spousal support order, the court shall satisfy itself that a change in the condition, means, needs, or other circumstances of either former spouse has occurred since the making of the last spousal support order or the last variation order made with respect to spousal support, and so that they can take those changes into consideration. This might also be necessary even when you just want to terminate spousal support or terminate child support. Factors for the parenting order or contact order. Before the court makes a variation order in respect of a parenting order or contact order, the court shall satisfy itself that there's been a change in the circumstances of the child since the making of the last order or the last variation order made in respect of that order. And who can make an application to vary an order under the Family Law Act? Either parent can apply to vary the order or file a motion to vary the order, or a person who's standing in place of a parent who has parental responsibilities. So we would sometimes refer to that person as in loco parentis, where they stand in the place of a parent, commonly a step parent, for example. If they have obligation to pay support, or they have rights to access or parenting time or visits with the child, or a person standing in the place of a parent who does not have parental responsibilities under the order if there's leave of the court. So even if under that original order you didn't have that in place, a finding that you are in loco parentis or in the place of a parent, you could still apply with leave of the court. And who can make an application to vary an order under the Divorce Act? So similarly, court of competent jurisdiction. So in Manitoba here, it's the King's Bench, may make an order varying, rescinding, or suspending retroactively. So they can vary retroactively to adjust it, or usually also prospectively. A support order or any provision of one on application of either both former spouses. for a parenting order on application by either both former spouses or, again, somebody who stands in the place of a parent or in loco parentis. And a contact order or any provision of one on application by a person to whom the order relates. So a person to whom the parenting order in question does not relate may make an application with leave of the court again. So if you were not included in that original order, but now you'd like to vary it to be included, usually a step parent in loco parentis with leave of the court.
Yeah, looks like there's just a question already in the chat there.
Oh, great. Thanks. Can someone continuously file a notice of motion to vary as a legal strategy? Example, once one variation is resolved, another motion is filed within a month and so forth. Is there anything in place to prevent this type of legal tactic from occurring? Okay, so my question would be, once you filed one notice of motion to vary, and that's resolved within a month, what could possibly have been a material change in circumstance that would necessitate another motion to vary a month later that hasn't already been resolved? It's possible. Like I've had a file before, for example, where say somebody settled everything this November, and in March or April, the child has decided that they want to change schools. It's really important to them. They have an important football program. It's not a year later, but we're already within a year filing a motion to vary. So that can happen. But if it's a legal strategy, you're feeling like there's actually no merit to the continuous motions to vary, and you're having to respond to them and file, we'll probably get into the actual forms that you need to file here, but you want to prevent them from being able to file what we would call frivolous and vexatious material before the court. You would have to file a request to have them found as a vexatious litigant, and that's very rare, but in some certain cases, the court may find that somebody is a vexatious litigant and it will prevent them from being able to file material that you have to respond to without like further leave of the court, proving to the court that this is a legitimate reason to have to file further motions to vary. Okay, and then I see another one. If the parent paying support has increased expenses, such as buying a home and having all the expenses that go with that, such as mortgage heating costs, is that cause for application for review? So typically the paying parents' expenses are not necessarily relevant to child support, because it's typically, this is what your income is, this is how many children you have that you're paying support for, this is the province you're living in, so this is the amount, regardless of what your actual expenses are. So that wouldn't necessarily be a material change in circumstance that would require a variation of a court order. Okay. Okay, and I should clarify there too, because that just kind of brought something to mind where you said an application for review. So when I've described, you know, the first kind of hurdle here that you have to prove that there's a material change in circumstances, there are some cases where people are not confident that they are in a position to agree to something on a final order basis. They think something's coming down the pipeline that might want them to have this reviewed, and they're not confident that it's going to be considered a material change in circumstance at that point. And so they want to cover off not having to prove that first step, that there's been a material change in circumstance, by having a review clause. So that's a little bit different if you have a review clause in your final order, saying that we're agreeing that this is what we're going to do for the next year, but it's reviewable upon, you know, January 1st, 2024, or it's reviewable upon receipt of a further assessment report, or it's reviewable upon whatever circumstance you want to put in there, upon the payer's retirement, for example. And then you've covered off that first hurdle. Have you proven there's been a material change in circumstance? You don't have to, because you've already agreed you're going to review it. And then you'd file a motion to vary for that review if you need to, if you can't come to an agreement. Okay, so thanks. I appreciate the questions when you jump in with those. So step one, you're going to file a notice of motion to vary, which is a Form 70H, or a notice of application to vary, which is a Form 70G. All of these forms can be found online on the King's Bench rules, the forms. And I'm sure Clea would also be happy to provide other information to people on the particulars of how you find that, where you get it in on the website. And you have to file an affidavit in support with your notice of motion to vary for your application, which is a Form 4D. Now, when you look at that form, it's going to be very blank. It will basically just say the title of proceedings and put your story or whatever you want to put in there in support of why you're asking for this notice of motion to vary. So we do have the King's Bench rules that kind of outline a little bit more about what has to be included in an affidavit in support of a motion to vary. And so the King's Bench Rule 70 covers off family proceedings, and in particular, variation of final orders and family arbitration awards is Rule 70.37. So you can also find this online under the King's Bench rules. So an affidavit in support 70.37 sub 2 says it has to include what the current marital or relationship status of the parties are, the ordinary residence of the parties and the children of the marriage or the relationship, particulars of what the current custody and access arrangements and particulars of any proposed changes, particulars of the current support arrangements and particulars of any proposed changes, the amount of any support arrears, and the particulars of any change in circumstance of the parties or the children since the date any prior order was made. And if you're asking to vary support, you have to include the date of the last spousal or common law partner support order or the family arbitration award. You should attach a copy of it to your affidavit. So when we see these, that's usually the first thing in the affidavit is attached here to, marked as Exhibit A, is a copy of the most recent order. And if there's been any subsequent, the final order, and if there's been any subsequent variations from that order or updates through the child support recalculation service, if it's been varied by that support determination officer as well. Particulars of the current support arrangements, particulars of any proposed changes, any change in circumstances since the date the last support order or family arbitration award was made, the financial circumstances of the parties when the support order or arbitration award was made, with copies of any financial statements filed by them in relation to that order or that award, the total income of the applicant in each year for which the variation is requested. So if you're asking to go back to, say, 2017, copies of tax returns going back that far for every year you're asking it to be varied. If the applicant's presently unemployed, the length of and reason for the unemployment, the particulars of any efforts to gain employment, particulars of any expenses the applicant shares with another person, the current financial circumstances of the applicant with any financial information required, and the amount of any support arrears, if the support was or is payable through the maintenance enforcement program, a printout of that payment record, because that's the best proof of what has been paid or what's owing. And if you're seeking a suspension of enforcement of the maintenance order, if you've already requested that directly to the maintenance enforcement program, what their response was. And if you're in receipt of money from any source, documentation to verify that amount in the particulars. And it's very similar to the requirements for child support variation as well. The ordinary residence of the parties and the children have to be included because that affects who's going to be paying support, what the amount is, if you have shared care and control or not. The particulars of the current custody arrangements, particulars of the current support arrangements, any change in circumstances since the last support award was made. So maybe the children have gone from living with parent A to living primarily or mostly with parent B, or they used to have shared care and control and now they're mostly living with parent A or mostly with parent B. So those are common circumstances where you need a variation order. Okay. So I discussed family arbitration awards as well, which is included in the rules. These are in circumstances where rather than have the court make a support order or award, the two parties have agreed to hire a private arbitrator, and that arbitrator has made the award. And so that's basically treated the same in here as a court order. So you file a notice of motion to vary the family arbitration award. And those are the forms and the rules that apply there. So the circumstances where you may use a notice of application to vary as opposed to a notice of motion to vary basically depend on where the order was made, the original order was made. If the original order was pronounced from Manitoba, then you're going to file a notice of motion to vary. Or if it was transferred to Manitoba from another province, so perhaps parties originally were living in Saskatchewan and transferred the order here. But if you're asking the court to vary, rescind, or suspend an order made by a court not in Manitoba, another jurisdiction, if it was made under the Divorce Act, so if they were married, then you can file a notice of application to vary. If there was an award or an order made in, let's say, for example, Quebec, and it was not pursuant to the Divorce Act, it was pursuant to provincial legislation, you cannot vary that award or that order here in Manitoba. You'd have to go back to that province that originally made it and ask them to vary it, because the court here doesn't have jurisdiction to do that. Okay, and sorry, I skipped to what to include in the affidavit. So all of these details. And similarly for the spousal support common law support order, these rules to be detail what needs to be included in that affidavit. So once that motion to vary is filed, or that application to vary is filed, then you have to serve it on the other party with your affidavit, your financial statement. And if you require information from the other party as to what their current financial circumstances are as well, you should also serve them with a demand for financial information. So once they've been served with that, if they're served in Manitoba, they have 20 days to respond. If they're served in another province, 40 days. If they're out of the country, there's special rules about how you serve someone in another country, and it depends on whether or not they're a citizen or resident of country that is party to the Hague Convention. And so that can be complicated, but if they're served outside of the country, it's typically they have about 60 days to respond. And how they respond is they could write you or your lawyer or contact you and indicate that they're not consenting to the variation, or they have some issues they want to discuss with you, and they don't necessarily want to file in court right away. And if you agree, you can grant them an extension of time to be able to do that, because of course we always want to try and resolve things outside of court if possible, and we don't want people to have to file things in court that they don't necessarily have to if we're able to resolve it by consent. But if it's not going to be resolved by consent, and you know they're going to have to file their material, then what they need to file is a notice of opposition to variation, or if you've been served with a motion to vary that you are not agreeing to. And that's covered under Rule 70.37, sub 6.1. There's a notice of opposition to variation. You have to file your responding affidavit in support as well. You should address all the same things that you've had to that have to be addressed in the affidavit in support of the motion to vary. And if it involves any kind of support issues, financial issues, also your financial statement. And that's a Form 70D, all parts. So Part 1 as to income, Part 2 as to expenses, Part 3 is assets, and Part 4 is debts. Even if you don't think that that's relevant to what the support issues are, the reason the court wants all 4 parts of the financial statement completed are in situations where they're looking at whether or not there should be a retroactive child support award, or a variation or rescission or suspension or forgiveness of arrears. They want to see what people's assets and debt situations are, because that plays into whether or not, on a fairness basis, that support should be claimed retroactively or forgiven retroactively too. Yeah. And notice of opposition to variation, rule 70.37 sub 6.1.1. If you live in another province or territory, not Manitoba, the form that you would file 70H.1, notice of opposition to variation, is under the Family Law Act. And that's going to be substantially similar to the notice of opposition to the variation within Manitoba as well. And then request the application or the motion be converted into an application under section 18.2 of the Divorce Act. There's interjurisdictional support proceedings, and file form 70H.1, notice of opposition to variation, if the application or motion is made under section 17 sub 1 sub B of the Divorce Act. Okay, so then in terms of service, the person who is filing the notice of opposition also has to serve. And just a little bit more details on how service is affected. Say the most simple situation, they're both in Manitoba, they have to be personally served and by somebody other than yourself. Because an affidavit of service needs to be filed confirming that they've been served, and it's not going to be enough for you to say that I personally served them. So we would typically hire a process server to serve the other party, but anybody else can do it as long as they file that affidavit of service, which is their testimony saying that they have personally handed this person the document, so they've received it. If you're having trouble finding the other party to serve them, you can request an order for substitutional service from the court. So you'd have to file a motion for sub service, a notice of motion with an affidavit in support explaining as much information as you have as to their contact information and what you've done to try to find updated contact information for them. If you've tried Facebook or Google, if you know that they have a Facebook account, you can try to serve them through Facebook Messenger or social media. If you know they have an email address, even though that's not personal service, you could ask for special permission to serve them via email. If you don't know where they are, but you believe they're in contact with their mother and you know where their mother lives, by having documents delivered to her address. If you really have no idea where somebody else is, then you can also serve through the maintenance enforcement program if you're paying through there. And I see Dallas has said, maybe to save yourself the trouble of finding a party or a subservice motion, contact the previous counsel of record. Yeah, to see if they're still counsel or will be counsel. So that's another good way. If people have lawyers, they can serve through counsel. So I would typically accept service on behalf of my clients so that they don't have to be personally served. And if you've contacted them before you've even started this process and you just haven't been able to resolve it, typically counsel will cooperate by saying, okay, well, I understand we haven't been able to resolve it. And you're going to have to file this notice of motion to vary. I will accept service, or you can serve it through me. So that can work too. Or if you've tried to send a process server out and they can't find them, then you can have that process server swear an affidavit of attempted service that they've tried to locate them and have them served, and they were at home or the lights were on, they just wouldn't answer the door, then they can say that in an affidavit as well. Okay. So that's basically the process for filing the motion to vary or an application to vary in court. But I'm going to talk a little bit more about, okay, now what happens? We filed the motion to vary. The other party has filed their notice of opposition, and what are the next steps? So the process in court, once you've had all those documents filed, is triage. So this is a new process as of 2019, the triage process, and there are requirements the court wants to make sure that everybody has done before they will let you see a judge to help you resolve any kind of disagreements. So there's a certificate of completion of prerequisites. So the prerequisites all have to be completed. So they're going to want to know, and you're going to have to check off a box certifying, saying that all the pleadings have been filed. You're not seeking any amendments to a pleading. So for example, when one person had asked, what if somebody files a motion to vary a month later? If the first motion to vary hadn't been resolved, but something else has come up that you're like, oh boy, if I had known this when I first filed my motion to vary, I would have included a request to ask for this to be changed as well in my original one, you could request an amendment to that. So before you go to court, you're checking off that you're not seeking any further amendments to the motion to vary, and that you filed all the affidavits you intend to file. So once the responding party has filed their notice of opposition and their affidavit in response, you have an opportunity as the moving party to file an affidavit in reply to that. And that affidavit should only address any new matters or new issues that have been raised in the responding party's affidavit, because it's not fair and considered kind of foul play, and you could have a cost award against you for doing this if you split your case and if you haven't fully addressed everything in your original affidavit, and then just left information to your reply that then the responding party doesn't get an opportunity to respond to, because they can't file another affidavit without leave of the court, and which would be in some special certain circumstances, maybe they could ask for permission to file a subsequent affidavit. Then you have to decide whether or not you're going to conduct cross-examinations on an affidavit. And so that's an opportunity for you to test the other party's evidence, ask questions about it, probe it further, expand on it. So if somebody says in their financial statement that, you know, they're spending $500 a month on clothing or something, you can ask them how they came to all of those expenses in their financial statement, to really pinpoint and test that evidence, or to test their credibility. So the way you would do that is you would hire a court reporter, and we would have them come to our boardroom. So it's typically in a lawyer's office, although I've done it in the PA in a hotel meeting room. If you don't have a lawyer's office, for example, to use, that would be another way to set it up. And they're going to record everything that is said. So they will complete a transcript of the cross-examination. And then you would file that in court, a complete transcript of the cross-examination. And that can also be used as evidence at a final hearing. So you have to confirm whether or not you're going to do that, or if you're not going to proceed with cross-examinations on affidavits. You have to confirm that the parties have met to try to resolve this outside of court, because the court wants to encourage that. And then all the financial disclosure has been exchanged, or if it hasn't, that you have asked for an order that the other party provide you with financial disclosure that you need. So if you're trying to retroactively vary support, for example, and the other party hasn't provided their 2017 to 2020 tax returns, you'd have to file a motion to have an associate judge order that they be required to provide that. And current pay stubs to prove what current income is for both parties. So those are things that could be prerequisites. If there's parenting issues, if you want an assessment on what would be the best parenting arrangements in the best interest of the children, if you're going to have that ordered, you have to have that before you finalize your certificate of prerequisites. So once you have that all done, and you can check off all those boxes on the certificate of prerequisites, then you file a triage brief and a request for triage. That will be on a Tuesday morning at 9 a.m. you have to serve the other party, and they have 14 days to respond. So for example, if you serve somebody, let's say November 6th, they have until November 20th to respond. And then your pre-screening date would be on November 28th. The court would confirm that the other party has filed all of their material as well by November 21st. And then they would give you dates for triage. And a triage date would be on a Monday at 9 a.m. or 1 o'clock p.m. And you're supposed to get an hour with a judge, but they will typically give you as long as you are able to continue on in court if you need more time than an hour. And then that will be usually about 5 weeks-ish, I'd say, from the pre-triage screening date. And then everybody goes there that date. You've exchanged all your financial disclosure. You've gotten everything that you need to do to satisfy those prerequisites. And the idea is that triage judge will try to help you come to a settlement agreement, to a consent order. If they can't, then they will set a case conference date about a month. It's supposed to be within a month later. It depends on their schedule and the holidays as well. So for example, if you go to triage in May, you still might not get a case conference date until September. And then if you're still not able to resolve everything at that case conference date with the same judge that you had a triage, then you can have a hearing date for your motion to vary. They're also going to decide at this point whether or not this can be decided on affidavit written evidence, or if the issues are substantial enough, there's allegations of abuse or somebody having a mental health issue that prevents them from being able to continue to parent. They feel like there needs to be oral evidence, then they will set trial dates for that to be resolved. So if everything is going to be resolved on the affidavit evidence, then a hearing date will be just within a matter of months. But if you need a trial, those dates are typically 12 to 15 months later, where that would be decided. So that's kind of the court process there for resolving a variation. We always hope people do not need to go through that whole court process. I know that sounds like a lot, not something most people want to do. So there are alternatives, and the court encourages people to resolve things outside of court. So Family Resolution Services has free mediation services. Both parties need to be voluntarily participating in that. So you would sign up through the Family Resolution Services. Both parties have to contact them to confirm that intake, and then you'd be assigned a family guide, and they will try to help mediate the issues for you. So that's one process. Then you could also hire a private mediator if that's something you're interested in. There's social workers, psychologists, or lawyers who also act as mediators. You could also decide to hire a private arbitrator. So we talked about arbitration awards. An arbitrator must be a lawyer, I believe, who's practiced for at least 10 years. And that way you can skip this whole court process and you can agree on what the rules are going to be. So whether or not you're going to have oral evidence or affidavit evidence, whether or not you're going to have counsel present with you or not. And that can be helpful when you have an issue that needs to be decided more quickly, like a change of school issue, for example. Then you would be able to get trial dates or through the court process. There's also the collaborative law process. So lawyers who are trained through Collaborative Practice Manitoba to resolve everything outside of court requires you to sign a participation commitment agreement that you're going to resolve everything outside of court with those lawyers. And if anybody changes their mind later, then they'd have to hire new separate lawyers and start over again. But it really focuses people on, we're going to resolve this outside of court. So those are some alternatives to going to court. And then also the child support service over the past couple of years has recently made it a lot easier for people to update things and resolve things just through the child support service. So you no longer have to apply to court to get a suspension of maintenance enforcement. So that's a really good progress. So if somebody's been laid off or something has drastically changed with their income situation where they can no longer continue to pay the child support or support that's in the order, they need that just suspended. You can make that request directly to the child support service. All the information is online on the family law website, the government family law website, on how to do that. Contact them, the forms to fill out. So you would just attach documentation confirming, what has prompted your request for suspension. And then if they grant that, it's typically only going to be for about 6 months. The maximum will be to 6 months. And they may have some conditions. So they may require that you pay a certain amount based on what you say your new income, lower income is, or they may only suspend collection of the arrears if you're asking them to vary the arrears, and require that you continue to pay the monthly amount in the meantime. And if you don't, then they may lift the suspension and start collecting support again. Or you may notify them directly if it's simply a case of, children have aged out of being eligible for child support. They're no longer children of the marriage. They're no longer in school full-time and they can support themselves. And so you can provide that information directly to the child support service and opt out of that or terminate the collection of support that way. So those are new helpful processes for people. We did want to leave some time at the end of the presentation for questions here. So I think we have about 10 minutes if anybody had any other questions.
Yeah, if anybody has any general questions, feel free to put them in the Q&A now, and we do have a few minutes left for those. Okay, I see that one just came in, so I'll let you answer that one, Tanya.
So my understanding is that the new triage system's primary purpose is to expedite proceedings in family law cases for the best interests of families. How has this legislation influenced your caseload, and has the triage system indirectly led to deleterious results for practicing lawyers? Okay. So I think the purpose of the new triage system was to avoid cases where it was languishing in the court process for 8 years, for example. Let's say somebody initiated their proceedings in 2011 and they've gone through 8 case conferences and no trial date has been set, and there feels like there's no end in sight for them. Or the court felt like people were just going to case conferences, just requesting financial disclosure or requesting an order or referral to Family Resolution Services for an assessment. So now they require all of that homework be done before you even come to see a judge. So in some circumstances, this is good progress because people should have been doing that homework before anyways. And it's a way for them to make the most out of their time with the judge. And many people were doing that, but now it's required. So that's one of the positives about that change, I suppose. Although they had, even before they made this new triage system, a requirement that after 3 case conferences, a trial date needed to be set because people need an end date in sight. And they can't just continue to come back for case conferences. So how has the legislation influenced our caseload? So I'll say when this started in 2019, there was a significant kind of delay, drop in anybody being able to get into court because it was taking people a lot of time to catch up and get used to the new rules and be able to comply with them all. And it's a learning curve. So it's funny because people would ask me questions about it, and I'd say, I don't know, this process is totally new to me too. I feel like an articling student here, just learning the process again. But it's been about 4 years now, and I think people have gotten more used to it and streamlined it. There's been so many changes over the past several years to family law, the new case management system, COVID. There was a new Divorce Act that was pronounced or came into force in March of 2021, the new Family Law Act in July of 2023. So all the forms have continually been updated like every couple of years. And they're still fine-tuning things in the process. So there were some holdups with being able to have your certificate of completion and prerequisites accepted by the registry if it didn't match what the other party's certificate of completion and prerequisites said as to what issues were settled or what issues were still outstanding. And so it was just recently, for example, announced last week that they were no longer going to require that the party's certificate of completion and prerequisites match on those issues. And that as long as your triage brief matches what your certificate says. So there were kinks to work out, of course, and how people interpret the rules and the directions and how they're being complied with. It still takes longer to get into court, I'd say, than it used to before this new process, because you could file your material 20 days you didn't have to wait for the other party to respond. They didn't even have to file an answer before you could get a case conference. The case conference dates were available online. They were about 3 months out, so you could kind of get in within 3 months. And now to get into triage, I'd say like 6 months-ish to get into triage. Okay, but there's been some other questions. So what is the average cost to submit a notice of motion for variation if you had to go all the way to trial? Oof, an average cost. Okay, so I would tell people to budget about $10,000 to get to triage at this point with all that homework that you have to do first. And if you have to go all the way to trials, I would tell people to budget $20,000 as well. So it's expensive. And I think in the regular chat here, if somebody is in the process of divorce, but after trying to reach the other party, it becomes impossible what the person's able to do in order to finalize the divorce. That would depend on where in the proceedings you were at. If you filed a petition for divorce already, if they've been served, whether or not you can note default, if they filed an answer and they've just dropped out of the process, but you still want to proceed, then you could ask that their pleadings be struck if they're not responding. So, okay, here's one of the hiccups that people have had to figure out with the triage process, because it requires cooperation from other parties. So in my example that I had given you, I said, you file your certificate, completion of prerequisites and your triage brief and your request for triage November 6th. And then the other party's supposed to file their material by the 20th or the 21st. And then what do you do if they haven't? Then you have to file a motion to compel them to complete the requirements to move to triage, that they filed their triage brief and their completion of prerequisites. So on the first motion before an associate judge on that, typically they'll make an order saying that they must do this within a certain amount of time. They may or may not order costs against the party, saying that they have to compensate you for this further delay and further costs for that. And then the second time you've had to do it, again, they will typically give them a little bit more time, especially if they're saying, okay, I've just retained a lawyer and my lawyer needs time now to do it. Now that you've ordered me to complete my part of the prerequisites to get to triage. And you may or may not get costs at that stage. I haven't gotten to a point where they haven't done it after that second order that they complete the prerequisites. But if they still don't do it at that point, I would expect that you would be able to ask that their pleadings be struck, and then you would be able to proceed on a default basis. Whether or not the court is going to grant that request will depend on the circumstances, of course.
Okay, maybe we'll give it a couple more minutes to see if any more questions come in, but I'm wondering if you could speak briefly to JADR, and if that's something that's commonly used to deal with variations or with just family law files in general, given that there is this whole triage and prerequisite process that helps parties deal with matters outside of court.
Sure. So a JADR is a judicially assisted dispute resolution process. And if you feel like your matter could be resolved if you had more time with the judge as a mediator, for example, then you can request a JADR. So if you're going to triage and you get the half day with the judge there, I've never heard of somebody having a 9 o'clock triage day going past noon. But they might, I don't know. But if you feel like you need a whole day, then you can request that from the Associate Chief Justice Hatch right now, and submit 3 or 4 judges that you would like to be assigned to be your JADR judge, and the court can grant you that time and that judge to be able to come to do that mediation for a full day with a judge. At that JADR, you might agree, you might have a pre-JADR conference and say, okay, this is what we're going to do. This is the plan. I'm going to file a brief, then they're going to file a brief, then I'm going to have a chance to file a reply brief, for example. Or there may be no briefs, or there just may be one from me, one from you at the same time. And then the judge will meet with all of the parties all together in one room. And then they might decide that this is going to be more helpful if you break out into separate rooms. And so then they might put the other lawyer and that party in another room and keep you and your lawyer in the room you started in, or vice versa. And then they might go back and forth and caucus between the two of you and see if they can help you come to a mediated resolution. I've never been to a JDR that hasn't been successful. So it is very useful. And it can be a way to avoid having to go through a trial, for example. Is there a motion to dispute a suspension of support made directly to the child support services if someone believes this is an intentional form of underemployment? No, they don't have that process as far as I'm aware, although I know that it has been raised as an issue with the changes to the legislation that allow people to make a request directly to the child support service for suspension of enforcement, that there isn't an opportunity for the other side to respond to that and say, whoa, no, wait, they're not employed. They quit their job for no good reason, or they were arrested for a very good reason. And so we shouldn't be punished by a suspension of an enforcement support in the meantime. The only kind of saving grace there is that there's a time limit to it, that it's 6 months. So the support might be suspended for 6 months, but if they haven't done something formally in court to formally vary that, then it will come back into being enforced within 6 months. What resources are available for people to afford these legal costs if they must go to a trial and continue litigation? There's legal aid. If they qualify for legal aid, and I know legal aid has kind of a pay for services agreement as well, where if you don't qualify for full eligibility, depending on what how many people are in your household and what your income is, where you might partially pay for legal aid, or if you have property, they might secure a lien against the home, where they're not going to ever force the sale of the home, but once it's sold, then you would repay them, and the amount that you repay legal aid is typically a lot less than it would have cost you for a private bar lawyer anyways. Other resources are CLEA, of course, Community Legal Education Association will give you information that might help you with the trial. There's the Legal Help Center where you can go in person and they will give you some help as well. They won't, as far as I'm aware, they've never represented somebody at a trial. Michaela used to work there and she's saying, no, they don't do that still. So those are some resources for people. And then they could always be self-represented if you really can't afford assistance. The disbursements can be expensive though. So even just getting legal aid for the purposes of covering off the disbursements, I think if that's an option and you're eligible for it, would be better than being self-represented. What if one party has access to independent counsel and the other does the state equal between parties? So if that means like one party has legal aid counsel and the other party is paying privately, how does the state equal between them? Legal aid always says that their certificates are not to be abused. If they're granting somebody a legal aid certificate, they have to have a meritorious case to be able to proceed. So they're not going to give them the opportunity to have legal representation and just have no grounds for disputing what you're asking for example. And then there's always the issue of costs at the end of the day too. And just because somebody has legal aid doesn't mean that they can't get costs against another party or that they can't be ordered to pay legal costs for taking unreasonable positions in litigation. How is domestic violence factored in when there are unequal power dynamics? So the new Divorce Act requires the court to consider domestic violence in any orders. So that is supposed to be taken into account by the judges in making any kind of parenting arrangement. It doesn't really factor into support, is mostly going to be just based on the numbers, regardless of whether or not there was domestic violence between the parties. Are there eligibility requirements for applicants seeking family resolution services? Nope, that's open to everybody. Similar to legal aid. So no, it's not similar to legal aid in that respect. You don't have to prove that you're unable to afford like private counsel or private mediation services. Anybody can use it. Do support arrears ever get suspended permanently? No. There's just the limit of 6 months, and then you have to get it formally varied through court. And the child support service will ask for documentation to show that, are you doing this? Like, you're not just sitting on the suspension for 6 months. So you're like, prove to us that you've actually filed the material that you need to get this resolved through court. Can you review the process of varying a Manitoba Family Law Act order when the other person lives in another province? Okay, so interjurisdictional support issues, then I'm going to assume, because it's going to be hard to share parenting arrangements between provinces. How does this change if it is a parenting order and the other parent now lives with the child in another province? Okay, so that's complicated. I'm going to try to think through how this would work. So if you have an order from Manitoba saying, let's say, for example, you're supposed to be having alternate weekend parenting time, and the other parent who has most of the parenting time has moved to another province, let's say Alberta, that parent is required to give notice of a relocation before they relocate. So 60 days notice. And then if they've had most of the parenting time, the obligation is on the parent who lives in Manitoba to say, I'm objecting to this, and file a notice of objection. Otherwise, the parent has the presumed ability to move. And so then if you want to formally vary that order, okay, so the order is made in Manitoba, you can file a motion to vary in Manitoba because we would have jurisdiction, but the other parent might say, depending on what the timeline is here, I've been living in Alberta for 2 years now. This is our habitual residence. This is the most appropriate forum or jurisdiction for this to be resolved in. If they just move there and you're trying to get them to come back, I think it would still be Manitoba's jurisdiction. Okay, I hope that answers that question as best as I can there.
We have a couple more questions that are coming in the chat here.
Yes, so I'm just seeing. Okay, so WCA, I used to work at the Winnipeg Children's Access Agency. So what can be done in the situation where you have a protection order that says the party cannot have direct or indirect contact with the other party? The one party calls for service, but require both parties contact for service. So that person would have to get a variation of the protection order to allow for them to have contact if they want to have direct communication, like in writing about parenting arrangements. For the Children's Access Agency, same thing. If they want to be able to have, if they consider that indirect contact, like from what I understand, what it used to be, at least, it was the visiting parent had to arrive 15 minutes before the parent bringing the children. The parent bringing the children would drop them off at another door, and then they would have their visit. Then the parent would pick up the children leave with the children, and the visiting parent had to wait 15 minutes before they could leave, so that there should be no contact between them during those visits. But if there's concern about like the distance between them then they might have to apply to vary that protection order. And similar process, affidavit in support, it shows up on, there's a separate protection order hearing list. So it's not exactly the same process as triage. And then if you're trying to set aside or vary protection order from that protection order set aside list, you would get a hearing date like within a couple months. And it's usually just like a 1-day trial to deal with that. And can we email the slides after the presentation? That's fine with me. Michaela, I'm assuming that's fine with you as well. Yeah. So Nina has them. Okay. Does domestic violence include child teenage abuse? Yeah, I would say so. Although if it's with respect to the children, typically there's going to be a child protection agency involved as well. So first contact is usually Anchor. They will typically do an abuse investigation. They may say or direct the parties that they don't think that there should be contact between the parent and the alleged abuser in the meantime while they're doing their investigation, or they may not say that. So typically follow their direction and their lead on that. And then they would have a abuse report finding whether or not the allegations were substantiated, unsubstantiated, inconclusive. And then you kind of have to take that and decide how that's going to affect the parenting arrangements on a go forward basis from there. And you can request disclosure of the Anchor abuse records. But you have to do that through a motion in court, and there's very stringent protections on that, so you can't disclose it to any other parties. Okay. So Wayne says, oh, you're talking about how does the other parent then know that one parent wants to use the access agency? So if they have lawyers, I've never had it be an issue for the lawyers to communicate between each other. I've talked to a Crown prosecutor before just to confirm for one of my clients who wasn't able to communicate with the other party that this isn't going to be an issue, that I'm communicating with the other party to try to negotiate this or figure this out. And I think that the Crown prosecutors take a practical approach to that and wouldn't charge somebody with breaching a protection order for doing something like that. So if the one parent calls and wants service, but we cannot call the other party because we don't have their contact information, both parties need to agree for service. They'd have to have some kind of third party between them doing that communication. So it could be one parent, one party's parent might do that, or a sibling might be that go-between person for them. And I know that sounds like that's indirect communication, and it kind of is. But practically speaking, they have to do that. And I've checked with the Crown before, and at least the Crown that I spoke to said that they wouldn't have an issue or charge somebody with breaching a protection order if that's what the arrangements are. If they don't have lawyers, or they don't want to use the lawyers because it's expensive too, to have a lawyer be your go-between communication person, to have that third party friend in between them.
Okay, thank you everybody for the questions. I think we are going to wrap things up here. I want to say thank you so much to Tanya for being here today and for presenting. That was an excellent presentation. I'm sure everybody learned a lot, and we really appreciate your time that you spent on this. Thank you as well to Michaela for preparing the PowerPoints and for being willing to share it and for keeping an eye on things here today. It's very, very much appreciated. And thank you also to all of our attendees here today and for all of your excellent questions. For anybody who has any follow-up questions, you can always get in touch with me directly or with our law phone-in at CLIA. I also, as I mentioned, would really appreciate it if everybody who attended today could fill out our post-webinar survey. That really helps us out a lot. And with all of that being said, I hope everybody has a great rest of the day and a wonderful weekend. And thank you again.